მოგესალმებით. დიდი მადლობა მობრძანებისთვის. დიდი მადლობა ივან ჯავახიშვილის სახელობის თბილისის სახელმწიფო უნივერსიტეტს, რომ დღეს ეს შესაძლებლობა მოგვეცა შევიკრიბოთ აქ ამ აუდიტორიაში. და დიდი მადლობა ყველას მობრძანებისთვის, დიდი მადლობა სისხლის სამართლის საერთაშორისო სასამართლოს ამ შეხვედრის ორგანიზებისთვის. მე ვფიქრობ, ეს არის ძალიან მნიშვნელოვანი ეტაპი საქართველოს თანამედროვე ისტორიაში. დაუსჯელობის სინდრომი, რომელიც წლების განმავლობაში არსებობდა ქვეყანაში, უნდა აღმოიფხვრას და ამ მიზნით სისხლის სამართლის საერთაშორისო სასამართლოს ჩართვა ამ პროცესში არის განსაკუთრებით მნიშვნელოვანი. მით უმეტეს, როდესაც მანამდე 2008 წლამდეც არაერთხელ ჰქონია ადგილი ქვეყანაში შეერაღებულ კონფლიქტებს და ასევე მთლიანად რეგიონში, რომელიც ცნობილია ასეთი კონფლიქტებით და დაუსჯელობის სინდრომით, დღემდე ერთ-ერთ ყველაზე სერიოზულ პრობლემად კვლავ რჩება რეგიონში. სახალხო დამცველი არაერთხელ მოუწოდებდა საპარლამენტო თუ სხვა ანგარიშებში საქართველოს ხელისუფლებას, რომ მოხდარიყო 2008 წლის ომის მძიმე დანაშაულებების გამოძიება, თუმცა ამ მიმართულებით პროგრესი მაინც და მაინც არ ყოფილა. მანამდეც ასევე მე და კიდევ აქ რამდენიმე ადამიანს ხედავ, აქტიურად იყო ჩართული არასამთავრობო სექტორში მუშაობის დროს, იმ არაერთი ანგარიშის მომზადებაში, რომლის მიზანიც იყო საერთაშორისო საზოგადოების და განსაკუთრებით სისხლის სამართლის საერთაშორისო სასამართლოს ინფორმირება 2008 წლის ომის დანაშაულებთან დაკავშირებით. მომზადდა რამდენიმე ანგარიში, ერთ-ერთი სწორედ ფონდ ღია საზოგადოება საქართველოსთან ერთად, სადაც რამდენიმე არასამთავრობო ორგანიზაცია, ადამიანის უფლებათა ცენტრი, მაშინ სწორედ ამ ორგანიზაციას წარმოადგენდი, ახალგაზრდა იურისტთა ასოციაცია, კონსტიტუციური 52 მოხდა და სხვა რამდენიმე ორგანიზაცია მონაწილეობდა. ისევე როგორც რამდენიმე სხვა მნიშვნელოვანი ანგარიში, რომელიც ნორვეგიის ჰელსინკის კომიტეტთან თანამშრომლობით მომზადდა და ზოგადად ის აქტიურობა საბოლოო ჯამში დასრულდა იმით, რომ მოგესალმებათ 2016 წლის 27 იანვარს დაიწყო ოფიციალურად გამოძიება ომის დანაშაულების, სავარაუდო ომის დანაშაულებების და ადამიანურობის წინააღმდეგ დანაშაულებებთან დაკავშირებით, რომელსაც ადგილი ჰქონდა 2008 წელს. ამ მხრივ ეს დღევანდელი შეხვედრა არის სწორედაც რომ მნიშვნელოვანი, მით უმეტეს, როდესაც არის დაგეგმილი საქართველოში სისხლის სამართლის საერთაშორისო სასამართლოს ოფისის გახსნა და ეს იქნებოდა მე ვფიქრობ ძალიან მნიშვნელოვანი მომენტი იმისთვის, რომ გამოძიების შესახებ ინფორმაცია მიეწოდოს ყველა მსხვერპლს, მოწვეებს, ასევე საზოგადოებას და ასევე ზოგადად ის, რომ ცნობიერება ამ მიმართულებით საზოგადოებაში იყოს ამაღლებული. დღემდე სამწუხაროდ ეს ამ კუთხით მე ვფიქრობ არის საკმაოდ სერიოზული გამოწვევები. გასულ წელს სახალხო დამცველმა ერთ-ერთი პირველი მსგავსი შეხვედრა გამართა მედიის წარმომადგენლებთან. ჩვენ გქონდა სემინარი, სადაც სწორედ ამ თემებზე ვისაუბრეთ და დღემდე საზოგადოების ძალიან ბევრ ჯგუფს აქვს საკმაოდ შეზღუდული ცნობა, ინფორმაცია ზოგადად სასამართლოს კომპეტენციის შესახებ, მისი მანდატის შესახებ, არის რაღაც გაურკვეველი მოლოდინები საზოგადოებაში და რაც ყველა ინფორმაცია მივიღოთ უშუალოდ ორგანიზაციის წარმომადგენლებისგან, ზოგადად ორგანიზაციის შესახებ, ასევე იმ საგამოძიებო ჩარჩოს შესახებ, რომელიც არსებობს დაზარალებულთა მონაწილეობაზე, ზოგადად ის, რომ საზოგადოების ყველა ჯგუფი რომ იყოს მაქსიმალურად ინფორმირებული ამ პროცესის შესახებ არის ძალიან მნიშვნელოვანი და რა თქმა უნდა ჩვენ გავაგრძელებთ, რა თქმა უნდა იგივე სხვა სტრუქტურებთან ერთად, ინსტიტუტებთან ერთად, ასევე არასამთავრობო ორგანიზაციებთან ერთად გავაგრძელებთ ამ მიმართულებით მუშაობას. ასევე ქვეყანაში არსებობს წლების წინ აქტიურად მუშაობდა არასამთავრობოთა კოალიცია საერთაშორისო სისხლის სამართლის სასამართლოსთვის და ეს კოალიცია დღესაც საკმაოდ აქტიურია და რა თქმა უნდა ჩვენ გავაგრძელებთ მსგავს მუშაობას და რაც ასევე მინდა აღვნიშნო, სახალხო დამცველის აპარატში უკვე 2 წელია მოქმედებს სახალხო დამცველის ადამიანის უფლებათა აკადემია, ანუ ერთ-ერთი ჩვენი მთავარი ამოცანა ასევე არის სწორედ ცნობიერების ამაღლებისთვის ხელშეწყობა ადამიანის უფლებათა საკითხებზე, არა მხოლოდ მონიტორინგი, ამ მიზნით ჩვენ უკვე არაერთი ტრენინგი, სემინარი მოვაწყეთ სხვადასხვა ჯგუფებისთვის და ზოგადად ამ მიმართულებით მუშაობა ჩვენ ერთ-ერთი პრიორიტეტულია, ისევე როგორც ზოგადად კონფლიქტით დაზარალებული მოსახლეობის დახმარება და სხვადასხვა ღონისძიებების ორგანიზება ამ მიმართულებით. მე არ მინდა რომ ძალიან გავაგრძელო, კიდევ ერთხელ დიდი მადლობა ყველას და დღეს გვექნება შესაძლებლობა უფრო დეტალურად ვისაუბროთ მთელ რიგ საკითხებზე. ამიტომ მე გავჩერდები, არ მინდა რომ ბოროტად ვისარგებლო ერთ-ერთი ორგანიზატორის შესაძლებლობით და მინდა უკვე სამართლის საერთაშორისო სასამართლოს წარმომადგენლებს გადავცე სიტყვა.
Thank you very much. I also would like to extend our gratitude to the university here, but also to Mr. Nanwashvili and to his office for their invaluable assistance in organizing this meeting with you. I can only stress again the importance of direct meeting between the ICC and the representative of the academic world. It is for us a very important occasion to be in contact with the persons who are leaders in the legal field and who are also forming the leaders of tomorrow of the whole society. And we believe that, of course, the main mandate of the ICC is to try to bring justice to the victims. But justice is not only about the victims. Justice is important for the whole society. And truth is important for the whole society, of course, as well. What we have found is that it's not enough to communicate directly with the communities that have been affected by the crimes. There is also a need to inform the whole population of what is the ICC, what is its mandate, and how it's conducting its mandate. And in a lot of occasions, the legal experts will be called by the media or by the public opinion to know from them what do they think about this ICC. Can they trust it? Is it really fulfilling its mandate? And of course, some of you are already experts on the topic. Some of you are already teaching about international criminal law. But others maybe did not have until now the time or the opportunity to specifically study this matter. And we thank you for your presence here today, for the time that you are giving to us in order to establish this first contact between us and you. But what we would like to have is really a long-term partnership after that for us to help you as much as we can in introducing teaching about the international criminal law and specifically about the ICC to your students, and for you to help us in providing everyone around you with the adequate information that you have and that you can have access to. Because we do know that if the right information and the correct information is not available, it will be replaced by wrong information. And wrong information would lead to rumors, misperceptions, lack of trust, or frustration, or false expectations. And all of that will damage the work of the court, but also will damage the trust in justice among the society, which is a very dangerous thing. So we need, on our side, to do our utmost in order to make this information available to you. And this meeting today, I hope, is only the first one, and it will be only a foundation done in order to build this long-term partnership later on. What we would like to do today actually reflects precisely these thoughts. we want to have a first session in which we'll be able to discuss about the court, the mandate of it, its jurisdiction, its activities, the work of the Office of the Prosecutor, and the rights of the victims before this court. And then in the second session, what we would like to discuss with you is how you envisage the possibilities of creating this type of partnership and creating joint programs for the future between the court and the academia world in Georgia. So with your permission, I would like to start by introducing the members of the ICC team that are here, who reflects also this variety of functions within the ICC. At my left, Mr. Anton Steinberg. He is the senior trial lawyer in the Office of the Prosecutor, who is in charge of leading the team that is working on the Georgia investigation. And to our right, we have Gabriela Gonzalez, responsible for the participation of the victims, for facilitating the participation of the victims in the proceedings of the ICC. And next to her, Vera Hanus, responsible from the Office of the Prosecutor for the international cooperation and specifically for the cooperation with Georgia. And last but not least, Greta Barboni, my colleague, who is in charge of the outreach and the public information related to the situation in Georgia, together with myself, Fadil Abdallah, I'm the spokesperson of the court and the head of the public affairs, or if you want to call it the public information unit at the registry. Why I'm making this distinction between the registry and the Office of the Prosecutor, I think because it may be a good introduction for you about the complexity of the ICC. It is one court, but with different organs who have to take care of very different tasks. The court has been created by an international treaty that we call the Rome Statute, because it was adopted in 1998 in Rome. There was a big conference with about 160 states. 120 of them adopted the Rome Statute. There was also a lot of NGOs and international organizations who also contributed to shaping this mandate and the rules that the ICC applies, specifically with regard to the rights of the victims, and that Gabriela will be able to explain later on. Currently, 124 states are parties to the ICC. And for a lot of people that were in Rome in 1998, that was already a great achievement that the court existed just 4 years after the adoption of the treaty in 1st of July 2002. No one could imagine at the time that 60 states will ratify just in 4 years. And no one imagined that 10 years later the number will be more than the double. But the success of the ratification of the Rome Statute is of course due to the work of the NGOs who tried, and the other actors of the civil society, who tried to convince the authorities in all these states of the importance of joining the ICC. But it's also due to the understanding by the states themselves that we need a strong international law to govern the relationships on the international level, and that impunity is not a choice, because if impunity continues, how they formulated in the Rome Statute is that the fragile mosaic of the society might be in danger. And specifically that happened just after the massive crimes that happened in Yugoslavia, in ex-Yugoslavia, and in Rwanda, and a lot of people were aware that we should not allow this to continue happening without any answer. The ICC is not the answer to everything, but it is part of the answer. It's part of strengthening the international law and its own institutions, at least for the ICC with regard to the crimes aspect. There are other institutions that are working on other aspects, but for the criminal aspects, when we are speaking about war crimes, or genocide, or crimes against humanity, as defined in the Rome Statute, these crimes do not concern only one country. When we are speaking about crimes against humanity, that means that it's a crime against each one of us as members of humanity. And the suffering of every victim is reflected in the soul of each one of us. And accountability and fighting impunity is the way, we all hope, to end the cycle of violence, but also to deter future violence from being committed again and again and again. So that's why I think a lot of states and a lot of civil society actors were enthusiastic to join the ICC. And Georgia was one of the first states. Georgia joined the ICC in September 2003 at a very early stage. And this is a sign of trust, that we trust this institution, but also that we need this institution to be part of the international scene to govern the relationships and to deter as much as possible the crimes that may be committed. I will not return on the definition in the Rome Statute of what is genocide, what is the crimes against humanity, what are the war crimes. The Rome Statute is accessible to you. I think that we have distributed some material and USB sticks on which you will have a lot of documentation that can be used on that. I just wanted to highlight that the Rome Statute built on the previous achievements in the international law scene. So the definition of genocide is related to the Convention against Genocide that already existed and has been already adopted. The definition of war crimes, for example, takes into consideration and already includes the breaches to the Geneva Convention and so on. So in that meaning, the ICC is in the continuation of the developments in international criminal law, but it also adds some special additional features, sometimes in the definition of the crime, sometimes in the rights of the victims, sometimes in the principle of complementarity that we'll mention in a few minutes, but also with regard to the jurisdiction of the ICC. So how it was designed, and because it's an international treaty, the ICC does not have a universal jurisdiction. It's not part of the United Nations system, it's not imposed by the Security Council. It's a matter, in principle, for each state to decide sovereignly to join it or not. And by doing that, the state that ratifies the Rome Statute is giving the ICC the authority to investigate and prosecute with regard to the crimes committed on the territories of this state, independently of the nationality of the potential perpetrators of these crimes, but also is giving the ICC the possibility to investigate and prosecute with relation to crimes committed by the citizens of this state anywhere in the world. This is a kind of alternative jurisdiction. It's either on the basis of the territories of the states that has given the ICC this authority, or based on the nationality of the potential perpetrator, and then we don't look at the territorial aspect.
Harry, can you stop for a second? They're going to switch interpreters.
They're switching the interpretation. Thank you, and sorry if I was speaking very fast. Okay. So I said that there is a kind of alternative jurisdiction with regard to the ICC. But to complete the picture, I have to mention also that there is a possibility to go beyond these conditions of the jurisdiction, because in Rome there was a discussion, okay, what should we do if, let's say, a government decided not to ratify the Rome Statute, but still this government or citizens of this state are committing crimes on the territories of this specific state. And these crimes have effect that sometimes goes beyond the frontiers, beyond the borders of one state. Can we just stay inactive, or they may be a way to actually ask the international justice to intervene? And of course, this need to give more authority to justice has to be also counterbalanced by the respect to the sovereignty of the states. We cannot impose on a state to accept the ICC if the state decided not to join. But there is an institution that has the legal authority to impose on this state the obligation to cooperate with the ICC without violating the sovereignty of the state, which is the United Nations Security Council. Because all members to the UN has already given the Security Council this authority of creating new legal binding obligations on them. We have seen that when the Security Council created the Tribunal for ex-Yugoslavia or the Tribunal for Rwanda. So it's also possible for the Security Council, without violating the sovereignty of the states, to impose on them an obligation to cooperate with the ICC. And the Security Council has adopted 2 resolutions regarding Darfur in Sudan and regarding Libya, which are not states parties to the ICC, and basically created a legal obligation on them to cooperate with the court. And when they do not cooperate with the court, they are actually violating the resolution of the Security Council, and the court will just inform the Security Council and leave it to the Security Council to decide on the appropriate measure. Now, this is regarding these basic conditions of the jurisdiction of the court. Where can the ICC intervene? Can intervene when war crimes, genocide, or crimes against humanity have been committed on the territories or by nationals from a state that has given this authority to the ICC. Or alternatively, if the Security Council gives this possibility to the ICC. It's also important to note the temporal element of the jurisdiction. The ICC cannot investigate any crime that happened before its creation. So anything before the 1st of July 2002 does not fall within the jurisdiction of the ICC. And for states that joins after, it's up to them to decide if they join only for the future, so after the date of their ratification, or if they want to give a retroactive effect, but not before the 1st of July 2002 in any case. Now, these basic conditions of jurisdictions needs to be triggered so that the ICC can actually start an investigation. And these triggering mechanisms, we divide them into 3. One is when a state that is party to the Rome Statute asks the ICC prosecutor to look into a situation where crimes have been committed. And then it's up to the prosecutor to make an independent analysis and decide whether or not an investigation should be opened. The second triggering mechanism is when the Security Council, similar to a state party, makes a referral to the ICC and asks the ICC prosecutor to look into a situation where the crimes have been committed. And again, the ICC prosecutor is independent. So an independent analysis will be conducted, and based on it, there will be a decision to open or not an investigation. We are never bound by these resolutions in the meaning that the ICC prosecutor does not have to open the investigation. It's her own independent analysis and her own independent decision to do that. Also, the Security Council and a state party cannot make a referral against a specific person, a specific individual. So they cannot ask the ICC to prosecute Mr. X. What they can do is to say, we notice that there are crimes committed, for example, in Darfur, in Sudan, in this period. And we ask the ICC to look into it, and we create an obligation for Sudan to cooperate with the ICC. And then it is for the ICC prosecutor to gather the evidence and to look, based on the evidence, who might be the suspects. That means that the states and the Security Council cannot make the referral naming specific individuals. It's the evidence that would lead the ICC prosecutor to the suspects. And later on, it's for the ICC judges to decide on these cases. And it's always about individuals, because we are speaking about criminal proceedings here. So the ICC is not designed to make decisions about borders disputes or disputes in between states or any different conflicts. It's only about individuals who may have engaged their individual criminal responsibility by ordering, planning, or organizing, and so on, these mass crimes that we have mentioned. There's a third way for an investigation to be opened, which is what we call the decision proprio motu by the ICC prosecutor to open an investigation. And that means that the office of the prosecutor might be receiving information from any state or organization or individuals or from open sources in the media. And then the office of the prosecutor may, on its own initiative, decide to look further in the matter and see if there is a reason to open an investigation. And if the prosecution decides that yes, there is sufficient basis to believe that an investigation should be opened on the initiative of the prosecutor office, then they need to ask for the authorization from the judges. And this is the process that has been done for Georgia. After the war in 2008, the Office of the Prosecutor received information from various sources and decided to look into the matter. And looking into the matter is what we call the preliminary examination phase, where a certain set of questions has to be analyzed, including the jurisdiction conditions, meaning what type of crimes have been committed at which time, on which territories, or by which nationals, but also are they serious enough, or do they reach the level of gravity that is required for the prosecutor to open an investigation? Are they prosecuted on the national level or not? Because this is an important principle that we will speak about later on, the principle of complementarity between the ICC and the national courts. And whether the interests of the victims and of justice will be served if an investigation is opened. So once this analysis is completed, and sometimes it can take several years, for Georgia it took a lot of years, but for specific reasons that my colleague will explain later on, mainly related to the complementarity between the ICC and the national court. If the answer to this, to all these questions lead to the belief that an investigation should be opened, then the prosecutor may apply to the ICC judges for an authorization to open the investigation. This is what happened regarding Georgia. And these are the three triggering mechanisms for the jurisdiction of the court to start. After that, there is a process of investigation, of bringing evidence, starting a case against suspects, asking for arrest warrants or summonses to appear, and the whole judicial process can unfold from that. But in parallel to the work of the Office of the Prosecutor, there are also other tasks that has to be fulfilled. The Office of Prosecutor has to make the first decision whether or not to open an investigation. But as I mentioned, in some cases, the judges have to decide to authorize or not this investigation. And this leads me to the second organ of the ICC, which is the judges. Judges are elected by the Assembly of the States that are parties to the Rome Statute. There are 18 judges for a mandate of 9 years, non-renewable. And they are elected in a way to ensure that there is a gender balance, but also to ensure that all the geographical zones and all the big legal systems are represented through these 18 judges. These judges are divided into pretrial, trial, and appeals division. And this is judicial process that we can, if you want, talk about later. But they also elect among themselves 3 judges to be the president and the 2 vice presidents. And the president of the court and the 2 vice presidents do not interfere in the judicial activities of the chambers. They are there to help in organizing the work, but they don't have any say on the cases that are before the other judges. They have a function to represent the court, to meet with the officials of the different states and different organizations, to negotiate some agreements, and so on, and also to have a general overview on the administrative work of the ICC. But the main administrative work of the ICC, so all what we call the non-judicial tasks, are done within the registry of the court. And the registry of the court, in doing that, has to be completely neutral. And this is one of the reasons why we always highlight the distinction between the Office of the Prosecutor and the registry. The Office of the Prosecutor has the mandate to accuse someone, but the registry has the mandate to ensure that the trial or the proceedings goes as smoothly as possible, respecting also the rights of the defense and ensuring that the rights of the victims are effective, and supporting the judges with all their logistic needs to ensure that a decision will be made in the best conditions. So for the registry has to be on equal distance from the parties to a case. The registry has to support the different teams that are there, and also to protect the witnesses of the prosecution in the same way that the witnesses of the defense are protected. Because there is no specific interest in a specific outcome of the proceedings. The interest of the registry is that the proceedings goes in the best conditions, independently of its outcome. The outcome is for the judges to decide on. So the services of the registry has to be completely neutral and supports all the different participants and parties to the proceedings. And we mentioned a bit the registry because it's a big organ within the ICC. And because normally we tend to compare things in comparison with our national systems. And in my country, for example, a registry of a tribunal is a very small office. It's where you register the documents, basically. But that's because on the national level, there are different ministries and different agencies that can take care of a lot of different aspects. Of the security, of the detention center, of the financial aspects, of the recruitments, and so on. But for the ICC, which is a court and also an international organization, all these functions has to be within the court because there are no other ministries on which we can rely. So the financial aspects, the budget, the recruitment of the people, the protection of the witnesses, the security of the space where we are working and ensuring that there is electricity and there is running water and so on, all that has to be taken care by someone. And these functions are grouped within the registry of the court. But also there are additional functions grouped there, including supporting the lawyers of the defense. Very often the defendants do not have enough financial resources to pay for a team of international lawyers to represent them for all the trial. And then we have a legal aid program within the registry to support in covering this cost and to support also on the substantial researches and so on aspects of the work of the defense. And very similarly, we have to do the same for the victims. Since victims have certain rights and they can be represented by lawyers, we need also to take care of the costs for the lawyers of the victims who are, in all the cases that we have, unable to cover the financial aspects of this legal representation. So the ICC, and specifically the registry, has to support them with regard to that. And also, we believe that if we want the victims to exercise their rights, they need first to be informed about these rights. And that's why Gabriela and Greta are here, because we need to go to the communities that have been affected by the crimes under investigation and explain to them what they can expect from the court, what are their rights, and how can they exercise these rights. That's why we have this victims and participation and reparation section, and we have an outreach unit. And we have also to respect this principle of the publicity of the proceedings. This is part of the principle of fairness of the proceedings. For the proceedings to be fair, we need to respect the publicity of these proceedings. Of course, the judges may order that certain information remains confidential because it's necessary to protect, for example, a witness or to protect a different person that if this information will be revealed, they might be in danger. But the general principle remains the same. Proceedings should be public unless there is an order restraining that. And to do that, we have a website for the ICC on which you have all the public documentation with the records from all the participants. So any document that has been filed in a case, unless it's ordered to be confidential, you can find it on the ICC website. This is also why all the hearings in the courtroom of the ICC are also visible on the ICC website with 30 minutes of delay for protection reasons. But in principle, you can follow all these hearings also on the ICC website. We believe that this is not sufficient, so we have to go even beyond that. We have to explain some important decisions through press releases. We have to communicate with the general populations through media, through our social media networks on Twitter, on Flickr, on YouTube, and soon on Facebook as well. So we are trying as much as we can to make not only the proceedings public, but also accessible and understandable, so that anyone who's interested in following, they can actually follow what's happening at the court. Of course, they can also visit the courtrooms and sit during the hearings should they want to. And actually, we have like 15,000 persons that visit the courts every year to attend the different proceedings and to have a flavor of what is going on and how it's being handled. And if they are interested in more, they can find on our website and through social media the ways to continue following on that. Very brief element of statistics, if you want, before I leave the floor to my colleagues. Currently, the ICC has, as I said, 124 states parties to the Rome Statute. All of these states parties, they do contribute to the budget of the court in a different, to a different extent, because of course we cannot expect all the states to contribute equally if they are not equally in their economic development or in the number of their nationals. So the same formula adopted at the UN is also adopted for the ICC. All the states contribute, but some contribute more than others, without getting any additional rights for this larger contribution. This is an important element to highlight as well. The ICC has more than 900 staff members that represent about 100 nationalities. So we encourage nationals from states parties, but also nationals from states that are not parties, to participate to what we consider a global fight against impunity. It's an important element as well to highlight that not only geographical zones and legal systems are represented among the judges, but also that among the staff members there is this global understanding. And we encourage also a lot of lawyers to be on the list of counsels, because the victims should be able to communicate with, and also the defendants should be able to communicate with lawyers that understand their culture and their languages. That's also important. Last thing to highlight. Sorry, I'm interrupted also for the change of interpretation. So last element that I wanted to highlight is a kind of smooth transition to the work of the Office of the Prosecutor. Just on the statistic level, the ICC has opened 10 investigations, including Georgia. The Office of the Prosecutor is also conducting 10 preliminary examinations. So based on their results, we might have other investigations as well. The office has brought up to now 24 cases against 41 defendants. Currently, this has resulted in 9 convictions and 1 acquittal. and there are 3 ongoing trials now. There are other proceedings ongoing, and there are 14 persons that the ICC is asking the states to cooperate in arresting them and surrendering them to the ICC. This is also important to highlight. The ICC cannot arrest by itself the suspects. We do not have a police force. We will not violate the sovereignty of any state. We rely on the cooperation of the states where the suspects might be present on their territories to arrest them and surrender them to the ICC. Sometimes this is not possible for political reasons, because the states do not want to cooperate. Sometimes it's not possible because the person is at large, is protected by a militia, and there are battles and has not yet been arrested. But our firm belief is that ultimately all arrest warrants will be implemented, because the people who are at large, they might be arrested at a certain time, because political protection for some people might change over the time. And because we've seen in the experience of previous international judicial mechanisms like the Tribunal for ex-Yugoslavia or the Tribunal for Rwanda, that certain cases might have taken up to 15 years for an arrest warrant to be implemented. But for the Tribunal of ex-Yugoslavia, they issued 161 arrest warrants. All of them have been, at the end, implemented, even 15 years later. That's because there is no statute of limitations. These arrest warrants will remain valid until they are implemented. And we can rely on the network of 124 states that are parties to cooperate with the ICC to arrest these suspects. If not today, it will be in the future, but it will happen. And also we can ask states that are not parties to voluntarily assist the ICC in arresting these people. And this has happened in the past and might happen in the future. And whenever we have stronger cooperation from the states parties and stronger support from the civil society actors and from the academia and from the NGOs on the global level, that means that even the states that are not parties might be more inclined in supporting the ICC in bringing justice to these victims. On this note, I would wish to leave the floor to Anton to speak more about the work specifically of the Office of the Prosecutor, its investigation, and where are we now with regarding the investigation about Georgia.
As my colleague said, my name is Anton Steinberg. Just a little bit about myself. I'm a South African national. I was a prosecutor in South Africa for about 25 years before I was recruited to the ICC in 2010. My background is not actually in international law. My background is more in prosecution litigation. So if you have any complicated questions on the protocols of the Geneva Convention, I'm probably not the right person to ask. But what I do have experience in is investigating and prosecuting complicated and difficult cases. Closer? At the moment, I'm working solely on the Georgia case, Georgia situation. I'm supported by a team of prosecutors, a team of investigators, as well as cooperation advisor, Vera, sitting to my right. Just a little bit about the Office of the Prosecutor again. As my friend Fadi has said, with the Office of the Registry, Office of the Prosecutor is also bigger and more complicated than a prosecutor's office you might find in a national jurisdiction. So, in addition to lawyers, prosecutors like myself, we also include a division, the investigation division, which is made up chiefly of investigators. Detectives would normally be in the police or similar institution in the national jurisdictions. In addition to that, we have a division known as the Judicial Cooperation and Complementarity Division, where my colleague Vera works. the reason for this is that for the court to operate in many countries around the whole globe, we require assistance of our partner states, the states parties, as well as other states who may and often are prepared to assist us. So we have no right to go into a country and start subpoenaing phone records. We have no right to start recording people's phone calls, or even forcing people to give us documents. If we need to conduct that sort of investigation, we request those states who have that power to assist us, and they then, in most cases, will support us and help us get the evidence we need. Similarly, as my friend Fadi has touched on, we also have no police force or no army to go and arrest suspects. And again, we require the cooperation of our colleagues and our partners, states partners, to assist us in that regard. And so you can see that cooperation with various states around the world is a very important part of our function, and it is that function that is fulfilled by JCCD, as we call it. The investigations are conducted by multidisciplinary teams consisting of, as I've mentioned, lawyers, prosecutors, investigators, and cooperation advisors. But they're also supported by a number of specialist functions, such as our Protection Strategies Unit, which advises us on how best to approach and interact with witnesses so as not to put them in danger. Operational Support Unit, which advises us on the conditions in which we can operate in various countries where there may be risks to ourselves operating there. Our Knowledge Base Unit, which takes care of all of our databases and information technology. Scientific Research Unit, Evidence Registration Unit, the Gender and Children's Unit, which provides psychosocial report and advice regarding vulnerable witnesses, and various administrative support units as well, amongst others. So as you can see, it's quite a diverse and complicated complex office, and all of this to support our main function, which is to investigate and prosecute crimes falling within the jurisdiction of the Rome Statute. Fadi has also mentioned a bit about how investigations are triggered, about the jurisdiction of the court, criminal, temporal, subject matter, and personal jurisdictions, as well as the principle of complementarity. I'm going to turn then specifically to the Georgia investigation and talk a little bit about how that came about, why it's only in 2017 that we're sitting here and having this conversation. As Fadi mentioned, the ICC is really a court of last resort. One of the principles that was agreed and was key in the Rome Statute adopted in 1998 was that it was primarily the responsibility of the states joining that treaty to combat international crimes, serious international crimes. And it placed first and foremost the onus on those states, firstly to criminalize these crimes if they weren't already crimes under their legislation, and then to adopt the Rome Statute with all of its requirements of cooperation, but also to be at the forefront of the fight against impunity themselves. And it's only when there are conditions under which states either cannot investigate, either due to possibly the fact that they've been ravaged by war, the institutions have been degraded. Alternatively, there may be circumstances where they are not able to have access to certain parts of their own national territory. Or in certain circumstances, they may be unwilling to investigate and prosecute. And this we see where, in fact, it is the state itself that has been committing crimes against its own citizens. And you think that to be counterintuitive, but unfortunately it appears to happen all over the world and throughout history. So only when those conditions are satisfied does it trigger action from the ICC to open investigations and to actually try to arrest and prosecute people. Which is not to say that when serious crimes occur and come to our attention, we do nothing. And specifically in the Georgia case, it was very soon after the war of August 2008 that the prosecutor triggered the preliminary examination. And as part of that examination, we were in contact with the governments of the two states involved, obviously Georgia and the Russian Federation, and we began to inquire from them and ask for updates on whether they were investigating, what they were investigating, and what steps they were taking as part of that investigation. And as far as the government of Georgia is concerned, for several years we followed their investigation, and we followed the fact that they were taking statements from witnesses, they were conducting forensic examinations, conducting medical examinations, and taking all the steps which one would expect from a serious and genuine investigation. And it was only in 2015 when the government of Georgia officially informed the ICC and the prosecutor, the Office of the Prosecutor, that they were unable to progress their proceedings any further due to various circumstances, that this then triggered our investigation. Thereafter, the prosecutor moved swiftly to request the court, the pretrial chamber, to authorize an investigation. Since the government of Georgia did not itself refer the case to us, nor did the Russian Federation, so the prosecutor decided to use her proprio motu powers to open an investigation. And I'm not sure if Fadi mentioned it, when we go that route, there is an additional check on the power of the prosecutor, and that is that she must first get the authorization of the pretrial chamber, the judges of the pretrial chamber, before she can actively start investigating. Now, apart from observing the investigations that were going on in the various in the countries involved, the prosecutor or the office of the prosecutor during the preliminary examination can also receive information from a variety of sources. And this is done in the office of the JCCD. They have a section called SAS, a Situation Analysis section. Is that right, Vera? Not listening.
Yes, correct.
Thank you. There are a lot of acronyms, and it takes, even after 7 years, I still have to ask myself sometimes. And over the years that we were following the domestic investigations, they were also collecting a wealth of information from governments, from NGOs, local NGOs, international NGOs, and of course we're watching and reading with interest the various reports that were being produced by investigations such as the Tony Avini investigation, Human Rights Watch, Amnesty International, and your local NGOs, the August Ruins report, which was compiled by Open Society and its affiliated NGOs here, as well as from an open sources media reports and a number of individuals and the proceedings in the European Court of Human Rights. So at the time when the prosecutor decided to apply to the judges, she already had a wealth of information at her disposal, which she was able to place before the judges of the pretrial chamber to persuade them that there were indeed reasonable grounds to believe that crimes within the jurisdiction of the ICC had been committed during the course of this war. In January 2016, the judges were unanimous, although there was a separate opinion, but they were unanimous in the fact that the prosecution had established that, and they authorized the opening of an investigation. the parameters of which they defined as an investigation into crimes under the ICC committed in the region of South Ossetia from the 1st of July 2008 to the 10th of October 2008. Let me just, and I know this is a sensitive subject, particularly after some of the things that were said in the last few days, we refer to the area of South Ossetia purely as a geographical description and not intended to describe any sort of independent statehood or anything like that. It's just a convenient descriptor that is being used. Since then, a lot has been done, although perhaps not visible, publicly visible. As you can imagine, opening a new investigation in a new country, as is the case with every new situation, requires a great deal of foundational work. Before we can start operating in a country, we first have to reach agreements with the governments of that country, which set out the framework for cooperation, and that was done. Took a few months to finalize that with the government of Georgia. There's also the need to ensure that the court has the necessary staff and other resources at its disposal to conduct an investigation, which would include, for instance, the capacity to translate, field interpreters, etc., when dealing with a country which does not speak one of the languages of the court. And you can imagine finding Georgian interpreters is something which is actually not that easy, not being a large country. Also, to get the necessary skills in terms of local knowledge in our investigation staff, and various other logistical and foundational work. But since the 2nd of 2016, the prosecution has actively been conducting investigations. Even before we were able to put in place the country agreements and the interpretation, etc., we were busy interviewing persons outside of Georgia who had knowledge of the events of August, September and October 2008. But since the end of last year, we've also been conducting in-country investigations. You may ask yourself why you haven't seen any evidence of this, and the reason for that is that, in principle, the Office of the Prosecutor conducts its investigations confidentially. We will not arrive in town in large flashy 4x4s with ICC written on the side. For a variety of reasons, we need to conduct investigations under the radar, quietly and confidentially. One of the main reasons for that is the need to ensure, firstly, the integrity of the process, but also the safety, security, dignity, privacy of the witnesses and other persons with whom we have contact during the course of our investigations. One of the most important obligations we have as a court, but also as an office, is to ensure the safety of our witnesses. Although we come to try and do good, first we need to make sure we do no harm, and if we put witnesses in harm's way, that would be run counter to our obligations. So we need to contact our witnesses privately, quietly, and ensure they understand the need not to discuss publicly the fact that they have been contacted and may have agreed to become witnesses. We're going to now break for a few seconds while we change interpreters.
No, if you are just speaking for 2 minutes, if you are only speaking for 2 minutes, that would go. Yeah, but if you speak for really briefly.
But then I won't give more information. So.
Yes.
One of the another obligation that we have, which shapes the way we conduct our investigations, is well, two other obligations. The first is that, unlike many domestic investigative and prosecutorial services, our chief objective as Officer of the Prosecutor is not simply to convict people, but rather to uncover the truth. And we are required to conduct our investigations not only into incriminating facts and evidence, but also we are required to follow up on any evidence which might be exculpatory. So if we are prosecuting a certain individual and our case is that he was at a certain place at a certain time, and we uncover evidence to the contrary, we are obliged to follow up and investigate that as well. Secondly, when we come to the stage of proceedings where we have an accused before court, or a suspect first, after confirmation, an accused, we are obliged to share with that person not only our incriminating evidence, but also any exculpatory evidence we have, or potentially exculpatory evidence, and even further than that, any material we have which may be, any evidence we have which may be material to the preparation of the defense. And you will appreciate that there is a conflict between our need to protect witnesses, protect their identity, privacy, dignity, etc. on the one hand, and our need to disclose to the defense evidence that they may need, not only that we will rely on in court, but they may need to conduct their defense. And in order to balance these, it's very important that we only collect evidence from sources and witnesses that we are able to protect. So if a particular witness, even though that witness might have valuable evidence, lives in a country or a region where they're at risk, or they would be at risk if they were to cooperate with us and become witnesses, and are unable or unwilling to accept our protection, then we would not put that person at risk by calling them as a witness. I've been informed that we need to move on a bit further, so I'm going to try to perhaps cut out unnecessary parts. The one thing I do wish to stress is that the Office of the Prosecutor is independent. We may not take instructions from anybody, any government, any person, even the UN Security Council. We conduct our own investigations, and we do so objectively. So in this case, in the Georgia case, as in every other case, where there are two belligerents or multiple belligerents and accusations of crimes on all sides, we investigate all sides of the conflict. So we acknowledge that there are certainly victims in Georgia, but there are also victims on the other side of the ABL. And so we need to try and have a balanced approach to our investigation and look at it from all sides, and in all cases act impartially. The present case has been complicated by the cooperation issues. I'm pleased to say that we've received good support from the government of Georgia and good cooperation. Unfortunately, although during the preliminary examination phase the Russian Federation was in constant contact with us, since the Article 15 decision, that cooperation has been rather less forthcoming. We do continue to seek to engage with the Russian Federation, and we hope that the situation will change in future so that we might get more active support. Similarly, it is necessary for us to engage with authorities in the South Ossetia region. Again, after some initial expressions of willingness to cooperate, unfortunately at present, that has not been forthcoming. We take note of the change in the administration of the area, the de facto administration, and we will continue to engage in the hope that we might get cooperation and access to the actual scenes of crime. However, the fact that we don't have that cooperation and we don't have that access does not stop us investigating. This is certainly not the first case where we face this sort of hurdles, and I can point to, for instance, Libya and Sudan, where we have investigated and issued warrants of arrest on the basis of evidence we've gathered. It is unfortunate, though, in that we would prefer to place or to consider ourselves in making our decisions, and also to place before the judges a complete picture. And by denying us access, unfortunately, those authorities have also denied us access to their point of view, as opposed to just the point of view of those people and that evidence we can gather. So we continue to pursue that, to try and get their cooperation. A question we're often asked is, how long will an investigation last? And the answer is, unfortunately, it will last as long as it takes to gather the evidence necessary to bring a case to court and bring it to conclusion. In the early years of the Office of the Prosecutor, under our first prosecutor, we had a policy of targeted and limited investigations, where we would go in light and resource light and try to get as much evidence with as few resources as we could and bring cases as quickly as we could. And while the prosecution was quite successful in doing that, the result was that by the time cases came to court, often the evidence wasn't as strong as it needed to be to withstand judicial scrutiny and attack by the defense. So under the new prosecutor, that policy was changed, and we now aim to be as close to trial ready as we can by the time an accused comes before court, which means that we don't have closed, time-limited investigations, but rather the length of our investigations is guided by the needs of the evidence. Of course, we are aware of the maxim, justice delayed is justice denied. It's been a long wait already for the victims, and we do acknowledge that, and we do try to move our investigation along as swiftly as possible, focusing on those areas of the investigation which would seem to promise the best results in the shortest time. But I can't give any timelines at this stage. I think that would probably be all I have to say, but of course we are available to answer any questions.